Welcome to our next session about accountability in the private sector. We have three speakers that will give their presentations today in this session. And each of them will open up for Q&A. So our first presentation is by Dr. Sorka McLeod from the Center of Private Governance and the Faculty of Law at the University of Copenhagen. She's a member of the UN Working Group on the Use of Mercenaries, and her presentation is called Contradicting Incentives, Mercenaries, and Private Military and Security Companies in Transitional Justice Processes. And she's joining us through Zoom, so thank you very much. And go ahead, the floor is yours.
Thank you so much. I'm sorry I can't be there with you in person. I'm currently in Geneva, but I'm delighted to be able to join you for the panel, and I'd like to express my gratitude for being invited to present here today. And I do consider this panel and the conference more broadly to be a very valuable and useful occasion, but its limited scope does not allow me to address broader human rights concerns that hold significant importance within the international human rights framework. And these encompass various critical current issues, including ongoing occupation and escalating allegations of associated crimes, including a very deeply troubling accusation of apartheid. Now, I've been asked to speak specifically about mercenaries and private military and security companies in the context of transitional justice. And I just realized, and looking at the title slide, I was going backwards and forwards with the title, whether it should be conflicting incentives or contradicting incentives. And so you've got both titles, one on the slide and a slightly different one in the conference papers. But hopefully you get the general idea about what I want to talk about today. So I have just a couple of slides. I don't want to go in to have a whole lecture's worth of slides here. But I think it's really helpful when we're thinking about mercenaries and private military and security companies. It's really important to understand what, in fact, we're actually talking about, because we hear all sorts of different terminology being thrown around. So we hear talk about mercenaries, we hear talk about private military companies, private military security companies, private security companies, private security providers, stability operators. There's a whole spectrum of terminology. And the reality is that the only one that has any sort of legal definition is the term mercenary. So it's actually much more useful to think about what these actors are actually doing and what services they are providing on the ground. So we can think about them as a spectrum, all of which are capable of violating human rights, and in some cases international humanitarian law in some form or another. So at one end of the spectrum, we can have what I talk about as peacetime security guards. They more often than not are not armed, but they might, in some circumstances, have, depending on the legal framework in a particular country, they may have access to batons or to pepper spray or tasers. But this group are generally unarmed, and they have been given the authority to exercise the use of force in certain specific contexts. So we see them in shopping malls and nightclubs and in public transport in many places around the world. Then we can have a group that we can definitely say are armed, but in peacetime situations. So the most common example is the guards who are involved in money transfers. and so they will tend to have they will tend to be armed, and they will tend to have much greater personal protective equipment. So they will almost always have some sort of stab vest on. And the peacetime, the other forms of security guards generally do as well, but they will very often be wearing helmets and a more militarized look. Then we can talk about these actors who are involved in conflict affected areas, and we're sort of starting to get into the sorts of actors that we saw emerging in the conflict in the Balkans in the 90s, and then into the 2000s in Iraq and Afghanistan. These actors were ostensibly brought in to these situations to guard primarily people and assets. But of course, they may also offer other types of services. So we start to see them offering military services, training of military personnel. Now, this is perfectly legitimate and permitted under international law. Where we get into proper mercenary territory is when we see them directly participating in hostilities, and they are providing combat services. And so we have seen in recent years a really substantial increase in the number of actors on the right-hand side of this spectrum. And most recently, we have seen a very substantial increase in the number of mercenaries or mercenary type actors who are directly participating in hostilities. Now, of course, the terminology direct participation in hostilities is a controversial one. States are not agreed on that. So you will find that there's a real division between states who will say that these kinds of actors, private military and security companies, are not mercenaries because they are not engaged in offensive activities. They're engaged in defensive activities. And so we get this an attempt at a very nuanced separation of the different types of actors. But many states do consider private military and security companies to meet the international legal definition of mercenary. So what is that definition? It's a very complicated and complex definition. So we look to the additional Protocol 1 of the Geneva Convention, Article 47. Now, it's important to recognise that this provision, in being part of Protocol 1, is dealing specifically with prisoner of war status. And so it does not criminalise mercenarism. It merely provides that if somebody meets this definition of mercenary, they are not automatically entitled to prisoner of war status. And it's a cumulative definition. And if you look at the first three, that's very much about the individual, and it's very difficult to prove and is very subjective. So you've been recruited specifically to fight. You do in fact take part in the hostilities in terms of fighting again. But this again depends on the perspective. And you're motivated by private gain, but it's private gain that is substantially more than a regular member of the armed forces, and it raises all sorts of questions about, well, how do you actually establish that? And then we get the sort of excluding factors of the definition, and so if you are a national of a party to the conflict and you're not a resident of the party to the conflict, then you will not be defined as a mercenary. So if we look at something like Ukraine, for example, if I'm asked, are there mercenaries in Ukraine? Well, the answer is yes and no. and it depends very much on their passport. So if there are, for example, Russian nationals who have been deployed, for example, on behalf of the Wagner Group, they have Russian nationality, they would not meet the international legal definition of mercenary. If, however, the Wagner Group deploys individuals, and we know that they have, who are not Russian nationals, so, for example, there was a Kyrgyzstan individual who's just been prosecuted and convicted of mercenarism back in Kyrgyzstan. So he, having been deployed to Ukraine, he's not a national of a party to the conflict. He therefore would meet the international legal definition of mercenarism, and indeed the national definition of mercenary in the Kyrgyzstan criminal code. Also, if you're a member of the armed forces of a party to the conflict, so you've been integrated into the armed forces, you are not a mercenary. And again, if we look to the Ukraine conflict, we have seen that there are numerous individuals who were not of Ukrainian nationality, but who were part of the regular armed forces prior to the invasion of Ukraine in 2022. And well, I'm speaking here in my academic capacity. The working group on the use of mercenaries has issued an allegation letter in relation to two British nationals and a Moroccan national who were convicted of both terrorism and mercenarism by the authorities in Donetsk. And but because they had been part of the armed forces of Ukraine, in the case of the two British individuals, for some years prior to the conflict of 2022, they did not meet the international definition of mercenary. And then the final definition is if you've been sent on official duty. So that could be peacekeeping duties, or it could be to do training or instruction. And what we've been seeing in recent years is that states are very concertedly trying to circumvent these international rules. So we see states recruiting individuals and then, for example, incorporating them into their armed forces. So recruiting individuals from other countries to become part of their armed forces to then deploy in a conflict. We have also seen countries saying that they have sent instructors or trainers to different countries on official duty. So we've seen Russia do that, for example, in relation to Central African Republic, where they said that they had sent trainers to train FACA, the car military. And what we've also seen in recent years is that states are operating as proxy actors in terms of recruiting individuals, particularly from conflict-affected areas. And this is, I think, a real challenge for transitional justice processes, because what we've seen, for example, is Turkey and Russia again, for example, recruiting individuals from Syria, for example, and taking advantage of the vulnerabilities associated with conflict-affected countries, poor development, not poor socioeconomic circumstances, and indeed in some situations, some of these examples that we know about, the individuals have actually been coerced or they've been fraudulently pushed into signing up to become mercenaries. So in some cases, some of them didn't know they were going to become mercenaries. They thought they were going to become security guards. Others, threats were made against them and particularly the women and girls in their families. And so we're seeing a whole new development in terms of individuals who do meet the international legal definition of mercenary, but who at the same time are also victims, and they're victims of human trafficking. They meet the criteria for trafficking. So this is a new phenomenon that we've seen, and one that is clearly linked to post-conflict and conflict-affected environments, and I think is something that has to be borne in mind when we're thinking about transitional justice and transitional justice processes. So very quickly, I want to just ask the question: is there a role for mercenaries and private military security companies in transitional justice processes? And we know, of course, that transitional justice is a key mechanism for accountability and remedy for victims. And it's something that should go beyond criminal accountability. And this is one of the real problems we see with mercenaries and PMSC, is that there is very much a focus on prosecuting individuals for under criminal provisions. So I just mentioned the case in Kyrgyzstan from a couple of weeks ago. That was a prosecution under the criminal code, it doesn't address the systemic problems that we see, and the root causes and the reasons for people stepping into mercenarism, particularly. And we also see recruitment for private military and security companies. We also see that the advantage is being taken of people from the global south. They're being hired by private military and security companies, and indeed local people in conflict-affected countries are being hired by PMSC, and the labor standards are very, very poor for many of those individuals. But really, transition in terms of transitional justice processes, while more generally business actors have been considered in a variety of different truth commissions, what we do not see is consideration of mercenaries or private military and security companies. It's something that's really not being looked at, and to a certain extent, when you talk to peace builders and mediators, they talk about these processes needing to be inclusive, and that everybody should be around the table. Now, that's not necessarily a bad thing in, say, for example, say Colombia, for example, where you've got Colombian nationals who are non-state, part of non-state armed groups, but they are Colombian. They have an interest in the future of the country. They're invested in the future of the country. But the reality is, with so many of, well, certainly mercenaries by definition are foreigners, and in the case of private military security companies, in many circumstances, they are also foreigners. So we do have to ask the question: is it appropriate for these types of actors to be involved in such processes? Why do I say that? Well, if you look at mercenaries particularly, so the actors that are specifically engaged in combat functions, and so they're actually engaged in fighting, what we see is that they are actually involved in the prolongation of armed conflicts. And that's quite clear to see. And it's because they have a vested interest, as I said, they have a financial vested interest in a continuation of the conflict. And the longer the conflict goes on, the more contracts there are for them. And of course, one of the other things that we've seen in recent years, because of the proxy use of mercenaries and mercenary-related actors by states, we also see that they are getting access to natural resources. And this is particularly the case in West Africa and the Sahel region. And so again, there's no incentive for them to step away from from a conflict. They want the conflict to continue, and indeed we've also seen that they are actively involved in destabilization of peace processes. So if you look at Libya, for example, one of the provisions of the peace agreement was that mercenaries should leave Libya. So there are mercenaries that have been sent by both Turkey and Russia to Libya. They didn't leave. And so what that meant was that I think it was 2021, the general elections didn't take place. There was still too much instability associated with their presence in Libya. So when I talk about contradicting or conflicting incentives, this is exactly what I mean. That unlike other actors who may have a vested interest in peace, it's the complete opposite for these types of actors. So they may have this vested financial interest in prolonging the conflict. And there's also the question of their nationality. Now, as I mentioned, with mercenaries, by definition, they are foreigners. They're not nationals of a country that's a party to the conflict. So we need to think carefully about who do we want around the table. Now there might be good reasons for victims to engage with these kinds of actors in terms of wanting acknowledgement or apology, for example. But there's we have to think very, very carefully about whether we want to bring these actors round the table, and of course always guided by the victims. And of course, as soon as we're talking about nationality, because we're dealing with people who are foreigners, we then get into questions of extraterritoriality and jurisdiction, and how do we ensure accountability for atrocities, whether it's human rights violations or war crimes or crimes against humanity? How do we ensure accountability, criminal accountability, and then remedy for victims when an individual has gone home to another country? So it's not just about the transitional justice processes within the affected country. There are also these extraterritorial questions to think about as well. And I think I've probably used up all my time, so I will stop there. I'm happy to take any questions. Thank you.
Thank you very much for your presentation, and we will move on to the following presentations as well. Thank you very much. So we will continue to the next presentation, and then we will take some questions at the end at a Q&A. Our next presentation is by Camilo Ramirez Gutierrez, who is a lawyer and lecturer at Bosque University in Bogota. He is the founding member of the Colombian chapter of the International Institute of Human Rights, and his presentation is titled Voluntary Transitional Justice, the Thorny Quest to Investigate and Prosecute Third-Party Civilians in the Colombian Armed Conflict. Thank you very much.
Thank you very much. Thank you, Dani, Minerva Center, and all assistants for this invitation. It's a pleasure to be here. Okay, I try to explain a complex topic regarding third-party civilians in the context of the Colombian armed conflict. This paper, I have to say this, is a project with my colleague Daniel Quiroga, that is candidate and PhD and Graduate Institute in Geneva, and he can be here. Okay, following the first explanation by my colleague Sergio Jaramillo, I would like to talk about the transitional justice in Colombia. As is known, transitional justice has been a tool to to develop the truth on the facts and the behaviors in Colombian armed conflict scenario, which has special relevance because it has different armed groups such as guerrillas, paramilitaries, and state agents, as well distinct international crimes, as I tried to talk in this time. However, in the shadow of the belligerent theater is hidden other kind of non-state actors. There could be collaborators, financial supporters, even gangs and lords of war, who have been influential in making the perfect context of the irregular war, or in the ISIL framework called non-international armed conflict. In this sense, one among many of the most cherished innovation of the Colombian peace process of 2012 to 2016 was the transitional justice institution claimed compulsory jurisdiction over acts committed by non-combatants. Pursuant to the original peace agreement, the comprehensive system of true reparation and no repetition, and its crown jewel, as well as the special jurisdiction or peace, will be able to investigate and prosecute the so-called third-party civilians. For the first time, a transitional justice mechanism would adjudicate cases related to the acts committed by those who, although not technically involved in the military actions of illegal groups, had a voluntary financial or collaborate relationship with them. However, this innovation was ultimately victim of its own ambition. After a hearing discussion in the public opinion, it was eventually declared illegal under domestic and international law by Colombia's constitutional court. In its controversial judgments about this issue. Ever since third-party civilians can discretionarily decide to submit to the jurisdiction of a JEP in Spanish, raising legitimate question about the viability of voluntary transitional justice tribunal. Those in our after article, we want to trace the history of the short life and third-rate burial of the Colombian experiment with the third-party civilians, hoping to provide lessons for similar debates around the globe. So, but it is old-fashioned debate is our first question. Because, as you know, in the framework of the Second World War and some cases in South American post-dictatorships, as well as Chile case, one of the relevant topics that were explored was the third-party civilians' liability or accountability. However, no one economic actor has been prosecuted by the Chilean justice, for instance, but in the case of Nuremberg and the 10 control law, we have some experiences such as the Flix, Grab, ING, Ferber, the bank workers, Poland research, and in fact, even the Cyclone B case. So there are both cases, referential situations, illustrate the processing of the non-state actors that strictly were not our actors or part of the confrontations. However, as you know, it is not a rule or deeper example of the prosecution of these relevant actors, because this topic has political implications for all contextual actors of the armed conflict or these situations of mass atrocities. But what about the Colombian proposal? In the framework of the peace agreement and the implementation rules in Colombia, one of the several topics that were argued was the prosecuting and investigating third-party civilians. These quite actors of the non-international armed conflict, old-fashioned known as financial supporters, have never been called by the transitional justice. As Sergio mentioned previously, for instance, 10 years ago, during the development of paramilitary jurisdiction called as Justicia y Paz or Justice and Peace, the competence was exclusive to former members of non-state actors group, non-state armed groups, but not for this financial, logistic, and training support. In contrast, in the first draft of the law that create and regulate the HEP, investigating and prosecuting non-state actors were possible, because during the 4 years of negotiation, as Sergio talked about, one of the most important statements was fighting and getting off all causes of armed conflict. And it required a review of the third-party civilians, because one of the important quests that we must answer in the transitional process, now in the IHL framework, is whether the parties of the non-international armed conflict are just the directed participants of the hostilities, wear uniforms in the field of the war, or there are other non-state actors. And it is the key point for this, I don't know, pillar issue, I don't know if named this. For this mission, the former government of the President Santos had the majority in the Congress or Parliament for us, and approved the first proposal regarding giving competence of the third civilian parties to have, although the opposition party had great support almost half Colombian society. I have to say, with misinformation, and maybe I have to do self-promotion for this paper where we talk about this topic of misinformation and the fall down of the plebiscito or referendum, and push up this opposition party, push up to change this rule from all fronts. And it's important, for instance, your question about the relevance of the local actors, because in the Colombian peace process, the opposition party was a special or relevant role to change and modify the rules to have implementation. But as I always said, as Colombia is a legalist country, the real scenario of discussion was the Constitutional Court, because it has a special competence on constitutional reforms and new statutory law, and the aspirational action for this court is to make a constitutional control, albeit in these constitutional controls, some actors had relevant roles inside the constitutional process, but others even from the public opinion. Those, the debate was legal and political, political and legal. Also, curious fact in the dish of the discussion have been many issues, such as the commander responsibility, the concept of the great crime of war, extradition guarantees, and the mandate of investigating and prosecuting third-party civilians. Also, some pledges were in the middle of the constitutional organization, in the middle of the constitution debate and the mass media debate, such as the ICC, International Criminal Court, human rights organizations, civil society organizations, ICRC, the Inter-American Court of Human Rights, the Academy, and the principal opposition party of the peace process. This last pledge is important for the topic of the third-party civilians because they call new faculty revenge justice. Revenge justice against those who suffered the effects of the armed conflict, as well as some economical actors or politicians. The strategy was to show society a version of the armed conflict and fight against the new meanings about who was the bad guy inside the armed conflict. However, the other half of the society pushed up to apply the new transitional justice and guarantee the independence of the judges and enforce the new legal framework. As a result of this story, Constitutional Court declared firstly that personal competence of third-party civilian is just a residual competence because it depends on the voluntary decision of the accused. And secondly, if she or he accepts voluntarily the competence of HEP, it can be on all crimes which have a relation with no international armed conflict. It is an important advantage for our competence because we can know international crimes regarding third civilian parties. This has been the turning quest to investigate and prosecute third party civilians in the Colombian armed conflict. Now, I would like to talk about relevant case which shows the importance of this topic as pillar of transitional justice enforcement. Sorry, I'm late with my slides. Okay. This is Salvatore Mancuso. This is a former leader, paramilitary groups. His case is very important nowadays in the framework of the transitional justice because he was in the first transitional justice, Justicia y Paz, and he was extradited for USA for traffic drugs. So this case is important because during 5 years of war, special jurisdiction has had to resolve some requirements to enter this transitional jurisdiction. Some of those have been presented by former members of the paramilitary groups. As I said, this is not the jurisdiction for this kind of members of armed groups because HEP is just for former combatants for FARC-P, former combatant of FARC-P, and military forces. But the Mancuso case is emblematic situation because he refers to one of the most important lords of war in Colombia. Mancuso has a particular story, as I said. Was former combatant in Colombia. He was in the former process of the mobilization, the paramilitary groups. After that, he was extradited in 2008 to the USA under traffic drugs charge. But inside of the Justice and Peace, was sentenced as a member of a paramilitary group 2 times for crimes of war war crimes, sorry, and crimes against humanity on 5,000 facts. However, a couple of weeks ago, he asked for entrance to help as a third-party civilian of the armed conflict and claimed that before he was a paramilitary member, he was a civilian supporter of the military forces to establish the paramilitary groups. In addition, he revealed other positions as a factor member of the armed forces, logistical supporter, and economical collaborator. As you can see, it is a special case where it is debated the traditional conception of the parties of the armed conflict and put on the necessity to extend the concept of the third-party civilians. This is Mancuso in his roles. And this is another interesting case. It is Otoniel, who was the supreme commander of the neo-paramilitary group called Los Gaitanistas Self-Defense of Colombia, or Gaitanistas, a non-state armed group post-demobilization, the former transitional process, and the traffic drug organization. He was captured by Colombian military forces and extradited to the USA too. However, before this action, he claimed the entrance of the JEP. He has a great story in the context of the armed conflict. Before his last position in Gaitanistas, he was a member of a guerrilla, EPL or EPL, which stands for Popular Liberation Army, and even was FARC member in the decade of the 80s. However, Osman Cuso, he said that before he became Supreme Commander of Gaitanistas, he was a third-party civil because he supported this group with economical resources. Albeit of this argument, he was not accepted because he didn't prove this condition, and in contrast, he had been expelled from the peace and justice process because he didn't leave the paramilitary structure. Other examples of third-party civilians could be these are armed collaborators. There are some gangs that collaborate with the former guerrilla. That kind of criminal groups kidnap people, and after that they gave people for the former guerrilla, but they were not members of the guerrilla. Other kind of civil parts are the politicians. This is a huge example. This is Salvador Arana. It is a former government in a town in a larger territory in Colombia, and he supports the paramilitary structures. In the frame of the JEP, he recognized that he suggests a paramilitary groups kill some opposite politicians. So this is other kind of third-party civil. And the last sample is the financial support. We have the classical case of study of this kind of non-state actors. There is the company that give financial support to create paramilitary groups. Currently, they are investigating in USA. No, so it's important for this reason. Let me say a few things. the current health practice go on the macro cases. Macro cases are the big situations where the third chamber try to investigate and prosecute the several crimes or most important crimes in the framework on the context the armed conflict. Nowadays, or no, last year, we opened the case 8 about the public force, state agents, crimes, joint paramilitary groups, and third civilians in the context of the armed conflict. This case is important because we have preliminary remarks, and this is the number of victims. The numbers are from the civil organizations, the regular or ordinary jurisdiction. We have some statements to begin this investigation and prosecution for third paramilitary security forces and members of the state agents. Other preliminary remarks. As you know, we have just 23 third-party civilians, but we figure out we have more and more because, as you can see, they are in different types. And as conclusion, let me a moment. Okay. As conclusion, I don't know. The third request to investigate and prosecute third-party civilians in Colombian armed conflict, as you have seen, it had important implications for the success of the transitional justice and making lasting peace, because still some of those third-party civilians are in the shadows and feeding the current non-state armed actors who benefit from the illegal exchange, armed proselytism, and territorial controls. They are not just companies, but they are politicians, some state agents, not members of the armed forces, and common criminality, etc. And that's it all. Thank you.
Our last presentation by Yael Fiask-Wirtzman, a lawyer and the director of the International Criminal and Humanitarian Law Clinic at the Reichman University here in Herzliya. Her presentation is titled Holding Corporation Accountable for Mass Violations in Peace and Armed Conflict, Developing Frameworks and Persisting Loopholes. And afterwards we'll have a Q&A. Floor is yours.
Thank you very much. Thank you to the Minerva Center for this amazing conference and to allowing us to immerse really in this bubble of a 2-day sort of very thought-provoking exercise. Thank you to Dani and to Ron and Nofit and Michal. And to all participants, really. I think it's a wonderful example of how important it is to keep the academic space as free as possible, both internally and internationally, and to exchange ideas. And it's especially insightful to see practitioners as well as academics, or academics putting their knowledge in practice to create change. Yes, so I'm going to make a leap now from the JEP, from the Special Jurisdiction of Peace, that Camilo presented, a very already defined framework, to the jungle of strategic litigation of human rights representing victims against corporate entities. And to speak about this under the umbrella of transitional justice. So I look at corporate entities as both agents and objects of transitional justice. Also, I'd like you to keep the eyes on the ball on two different dynamics. One is the dynamic between working with corporate entities for the redress and reparations for violations of human rights. I'm talking about gross violations of human rights or international crimes, or working against them when there is no other choice. And another dynamic is how we're shifting from the state-centered sort of notion of justice to a victim-centered notion of justice, still under the framework of state-enabling judicial systems. I'll explain. Okay, so first, I'm going to talk about two things. One, I'll present two legal frameworks that are developing. They're both acting in parallel, but more and more they're interacting between them. And as they develop, I believe that there will be something more comprehensive out there. At the moment, we have multiplicity of means and so forth, but I'm going to present these two, for now, different or separate normative frameworks. The second thing I'll do is I'll present a few case studies very briefly, mainly to underscore the remaining loopholes. So a bit about the process and what we still are missing in terms of, for example, reparations or remedy, if we're talking about truth, justice, recognition, of course, reparation and non-repetition for victims. I'd like to start simply because this morning was inspiring to me, and also yesterday, with something from, I'll call it our sources, Jewish sources, stating that without truth there is no justice, and without justice there is no peace. But transitional justice recognizes that justice is not only or uniquely criminal accountability. You can have justice in other means. I think that's the Colombian example, and also the Northern Ireland example shows us the possibility to think out of the box. One of the pillars of transitional justice is accountability. So at times we're talking about, let's talk about transitional justice and accountability, but I'm looking at accountability as part of transitional justice. Now, traditionally, international law still focuses on state responsibility, later on with the revolution of individual criminal responsibility, and only recently corporate entities receive attention. The field of transitional justice is no exception. You have, again, only recently a multiplicity of strategic litigation for human rights exercises against corporate entities, focusing on the key role of corporate entities, as objects, those who commit or contribute to the commission of crimes and wrongs suffered by victims. So we're, this recognition of corporate entities as agents of power, and then comes without saying, then we have to also look at them as agents for redress. I'd like to mention also the Special Rapporteur's very recent 12th July 2022 report, the Rapporteur on Promotion of Truth, Justice, Reparations and Guarantees for Non-Repetition, the Transitional Justice Rapporteur, Fabian Salvioli report on the role of non-state actors in transitional justice, speaking of non-state armed groups, but also of corporations. Okay, so I've already stated, obviously corporate entities have power, and power, I'm talking about the broad sense of power. We can talk about a whole session of what power is. Basically, it's the possibility to influence, it's a mechanism of communication, it's a dynamic, power is not static, it's dynamic. It has to be accepted by not accepted, but power is sort of like a communication, even though it's not a communication of course, the victim chooses. Right. So, speaking about, if we talk about agency and accountability, I'd like to present very briefly two legal frameworks, as I promised. And the ambition really, as Ron stated in the opening of this conference, is to have this one conversation. So we have two legal frameworks, but I see the synergies between them. The first relevant normative framework, and I am a lawyer, so that's what I'm starting with, a normative framework, is the UN Guiding Principles for Business and Human Rights. And the second, happening in parallel, but again, increasingly with meeting points, is the civil and criminal law, simply. Domestically, of course, internationally, but we don't have an international court recognizing accountability for corporate entities as corporate entities. So, of course, Camilo showed us, and it's that's helpful because I don't have to go into the details. But, of course, at Nuremberg, international criminal law did hold trials against corporate entities. We'll go back to that. So first, the UN General Principles on Business and Human Rights. It is not until the 1980s that the role of corporate entities in gross violation of human rights gained awareness and reached public discourse. In 29th of January 1999, at the World Economic Forum in Davos, Switzerland, Kofi Annan spoke to hundreds of business executives stating, "I propose that you, so this is working with the business's leaders, and we, the United Nations, initiate a global compact of shared values and principles which will give a human face to the global market." So this sort of was the beginning of the modern corporate sustainability movement as we know today, the UN Global Compact. In 2006, Kofi Annan joined thousands of companies to launch the UN-backed Principles for Responsible Investment, the PRI, focusing on the impact of investment on economic, social, and governance implications. Finally, Kofi Annan appointed UN Special Rapporteur Business and Human Rights, John Ruggie, only recently deceased, who issued the UN Guiding Principles on Business and Human Rights. In 2011, the UN Human Rights Council unanimously endorsed the UN Guiding Principles, a set of guidelines divided into three pillars. One pillar focusing on the state obligations to protect human rights when we talk about corporations, and to sanction corporations actually when they're violating them. The second pillar on corporate entities' obligation to respect human rights. And the third pillar focusing on remedy for victims, the right of victims for effective remedy. And this is, of course, centering us right in the center of transitional justice. Especially relevant, very briefly, Principle 12, stating the scope of corporate responsibility to respect may be broader in conflict-affected contexts, as in situations of armed conflict, enterprises should respect IHL. Principle 31, criteria for ensuring effectiveness of non-judicial grievance mechanisms. Those to whom the mechanisms are intended are reporting obligation of risk to human rights. This is Principle 21. And obligation to cease or prevent, mitigate remaining impact. Principle 19. Okay. So later, the UN general principles were implemented by regional entities. If we talk about the OECD, the European Union, still implementing them. And domestically, the UN guiding principles are still being implemented by national action plans and also domestic legislation. The most forward-looking sort of progressive legislation recognized is in France, the vigilance law from 2017, entered into effect on January 2019. We also have a German law and an EU directive that is right now, as we speak, in Parliament in discussions. Still, despite these developments, all of these laws are still seen as too cautious, too apologetic towards corporate entities, and this is where I come to my second legal framework. So the second legal framework begins at Nuremberg. And it's here to say that corporate entities, it's not a voluntary issue. It's not something that you can choose to do or not. And states should really step up in, stating that clearly, non-apologetically, and also breaking the news to corporate entities. And the truth of the matter is corporate entities are already aware of this. If you see the amount of positions out there, in the last 5 years, looking for a human rights director and all these entities, things we didn't see in the past. My dad's dream, yes, you have something to do with human rights. You can work for corporate entities. That didn't exist in the days. So yes, corporate entities already know it's true, and national legislations must step forward. And they are in the process of doing that also in Israel. So for the second legal framework, international criminal, yes, very briefly. The IG Farben trial against the producer of Cyclone B gas chambers, the Flick trial against forced labor and financing of the Nazi Party, and the Krug trial for rearmament and forced labor. Now, the ICC doesn't hold corporate entities accountable, but the acceptance of organizational policy under the definition of crimes against humanity, you need a policy. Crimes against humanity are always systematic or widespread. And beforehand, it was limited to state policy, whereas now it's accepted that an organization can also have a policy. Therefore, even though the corporate entity won't stand trial, the individuals behind these corporate entities will be accountable. And they are being accountable at the ICC today. Now, the domestic setting is the main actor here for corporate accountability. And even though we'd like to think that it's completely new, it isn't. So in the 1980s, for example, there were a multiplicity of cases, namely about chemical weapons to Saddam Hussein. So we had cases in investigation in France, not a case. German cases, criminal cases with convictions, but the caveat there that it wasn't convictions for involvement directly, knowingly contributing to international crimes and atrocities against the Kurdish ethnic minority, but rather for violating extradition regulations on dual-use substances. So there's an argument there of how far-reaching that is, but there were criminal convictions. In the Netherlands, there was a conviction, and even the corporate entity was erased for a year as one part of the sanctions. So the caveats were always existent, but it seemed more like a hit-and-run exercise rather than a framework that creates legal certainty. So this brings me to the 4 cases. I'll briefly, I don't know how I am on time. Okay. So I'll talk about the 4 cases again briefly. And I'd like to underscore, the fact that they exist shows that there's an emerging framework, but my wish here is to underscore the loopholes to see what's still missing for accountability. So the first situation or case is the Syria and the Lafarge cases in plural. This has to do with Syria and ISIS. Lafarge is a French cement company, and it had commercial operations in the later on controlled by ISIS territory, but it was already existent before. So it was in the territory, and then suddenly the government changes, and Lafarge, instead of leaving, stays and also accepts to pay, let's say, taxes to ISIS, which is nothing else than bribery or, of course, financing of ISIS. And then, this is in the millions, very substantive sums of money that undoubtedly enabled much of the atrocities committed by ISIS. Now, the cases brought were, as far as we know of, because a lot of things are not always brought into the public, in the US and in France. So we see the 2 different structures, two different judicial structures, common law, civil law. In France, it's criminal investigations brought by the partie civile, the victims, and that means that the partie civile are asking, and NGOs are asking the investigative judge to open an investigation either against X or naming the suspects, And of course, the investigation is ongoing, and it's the investigative just sort of leads the process. There is a role for the victims there. They initiate the proceeding. They can move it forward. They can present communications and evidence. They are more than heard. They're really a partie civile. They're a civil party to a criminal case. In the U.S., the case against Lafarge was a state-led case. It was a prosecution, a criminal prosecution, and there the state negotiated a compromise, an agreement with Lafarge, admitting criminal responsibility for crimes, and paying a payment of $267 million. But, and here's the big but, paying this money to the U.S. Treasury. It doesn't go to the victims. Now, from the U.S. Treasury, it could go to the foundation, directed to victims of terrorism in general, any victim of any terrorism in the world under U.S. law. So not the direct victims of Lafarge implication in ISIS crimes. Especially if these crimes are not defined as terrorism. Some are and some aren't, so it's... Yeah. The second case scenario... No, just to say the French case is still ongoing. The US case is over, but again, the victims didn't see anything. Maybe they saw some kind of recognition of responsibility. Yeah. The second case setting happens in Myanmar, and this time I'll talk about Facebook, now known as Meta. I have to mention as well that Lafarge also isn't known as Lafarge anymore, so this is something that happens with corporate accountabilities. They can change shapes, they can change names. Lafarge was bought off by a different company and carries a different name altogether, and we could suspect that something with that reputation, is part of the reason for change. Facebook has changed its name to Meta. I don't know if it's related with the growing scandals involved with how the data is used by Facebook, Facebook with repressive regimes. And in the Myanmar case, Facebook as a contributor to the crimes definitely was used as a main tool in the hands of Myanmar generals in order to organize and carry out, I don't know how to call it exactly, exercises, expeditions that served nothing else than ethnic cleansing, forcible transfer of the Rohingya minority, with the frontier with Bangladesh. And basically genocide. So Facebook, it wasn't like a sporadic sort of use of Facebook. This was something that Myanmar generals used widespreadly, before an attack, during an attack. This is what's happening, carrying out orders and so forth. And Facebook has acknowledged this role. Till today, there is no, at least as far as we know, there is no any procedure in front of a tribunal, a court. The interesting part about this is Facebook is also playing, or Meta is also playing, an active role in redress for victims. And this is bringing us to another setting, the International Court of Justice. So we know that Gambia versus Myanmar case under the Genocide Convention, where Gambia brought a case to the International Court of Justice calling for provisional measures from the court against genocide. Now, the interesting part is that a lot of the evidence that Gambia is able to bring in order to justify these provisional measures that, by the way, were issued, is actively brought by Facebook. So thanks to Facebook, victims are receiving redress in some sort of way, but they're activating the judicial system that they wanted. So it's a very interesting role here, sort of active and passive of Meta. Definitely instrumental in providing the evidence. And without evidence, of course, we have no redress. The third case scenario is Eritrea, Nefson, Canadian Mine Company, and the Canadian Supreme Courts. So Eritrea, because of time, I'm going to be very quick. So we can also call it the North Korea of the African continent, a place where any man between the ages of 13 and perhaps 50, a bit above, does military service that has nothing to do with military service as we know it, but more slavery, disappearing, going very far away from his family, and with no communication, and actually working in these mines. And one company is Nefson. It's a Canadian company. Nefson works together with the Eritrean government, and this is absolutely, of course, a crime against humanity. The victims, 9 of them were based in Israel, and the connection was done with the Israeli NGO, the Hotline, an amazing NGO working here for years. The final line is they won. The caveat is how and at what price. So as many times, if we look at trials against corporate entities, about a decade goes to discuss preliminary questions of jurisdiction and admissibility. So is this case going to enter the court or just be rejected prima facie after discussion on preliminary questions? So this is a foundational stage of strategic litigations against corporate entities. Corporate entities, unlike individuals, are immortal. They have an endless amount of resources. We have cases, for example, against Nestle for child labor in the DRC, where the victims were children at the beginning, and now they're about 30 years old. So, time is a different concept for a natural person, the corporate entity, and actual individuals. And so also Nefson Canadian case was no exception, about 10 years for the crucial preliminary questions. The most crucial question, I think, was whether peremptory norms, so prohibitions under international that are jus cogens, to which there is no exception, for example, slavery, have to have a translation in tort law, in Canadian tort law. And the answer that the Supreme Court of Canada gave several times, because there are several, of course, litigators bring it to several rounds, was that if there is no effective justice mechanism under, for example, tort law, then this prohibition has no meaning, and that is impossible in law. You can't have a prohibition that is empty or void. You need to, if Canada is part of these peremptory norms, and all states are, peremptory norms are conventional, customary international law, then they have to be translated into domestic laws somehow, and tort law is that manner, and actually it's the least restrictive manner, because it could be also criminal proceedings, so it has to be something. Now the problem is 10 years of proceedings, and then again what happens in these cases is that once the plaintiffs win on the preliminary questions, then the corporate entities reach an agreement confidentially. So they pay a large sum of money to the victims, the lawyers who have been invested in these cases, much of the time pro bono and so forth. They get some kind of sustainable, even profit. They paid for their work, but it's all secret, so it's all confidential. So there's no case law. So the next time there's a victim plaintiff, we don't have any case law to rely on. We just have this news journal, sort of very succinct publication. Well, Nefson Company reached an agreement with the victims and case is closed. We don't know if there's an admission of guilt. We don't know if there's an apology. We don't know the sums. We don't know. And as a lawyer to these victims, you can say on the one hand, don't say no, we're going to win. We won the 10 years of preliminary questions. We can win the substance. The corporate entities know we can win the substance. That's why they want to reach an agreement now. But if you're really thinking about the best interest of your clients, then you're saying, well, you're 30, you're not 15 years old anymore. Maybe you'd like to move on with your life, and this sum will somehow enable you to do that. So there's a caveat there. And the final case is in the Sudan Darfur genocide case against the BNP. It's the National Bank of Paris. Just the French English there was BNP. And here too we have a case where this, like in Lafarge, both cases are in the U.S. in front of U.S. jurisdictions. The first one is state criminal jurisdiction, and again BNP reached a compromise, like in Lafarge, paid millions. The sums went to the terrorism trust victims. That's why in this case plaintiffs reached out to a civil lawsuit lawyer who's represented them until today in order to receive direct redress, punitive damages. And the case is still ongoing. That is the counterpart. So I finished with the cases, maybe conclusions. If we gather on the loopholes, then you can see the conclusions, but I'd like to open the reflection maybe on some points that are inherent. They'll appear in every case and are specific to strategic litigation against corporate entities. One is that corporate entities are not like non-state or non-state armed groups. They don't, most of the times, and they don't necessarily have an ideology in the conflict. So sometimes it's easier, I'm going to say this cautiously, but it's easier to accept someone committing atrocities. It's never justifiable, ever. But at least they have some kind of hate or love or something like that. This is a space of non-emotions, of numbness of heart. They're doing it for profit. They're doing it to have a better car. They're doing it to have a better house, a nicer house, not a better house, I'm sure. This is about money. It's about profit. It's not about ideology. It could be, in the Arab Bank case, victims of terrorism, for example, there was an ideology there that was part of reaching the conclusions of responsibility and accountability, but it's not necessary for corporate entities, neither accountability nor for their involvement in this. The second point is, again, that the regulator of the state has to get its act together and to tell corporations, I'm doing you a favor, and corporations are actually waiting for this. Tell us what the law, what are our obligations are relating to human rights when we act within our territory and also outside. It can be different contexts. It can be conflict or non-conflict. It can be repressive regimes. It can be supply chains. We need you to tell us what we need. And until you do, we're hiring private lawyers to tell us, and we'd like to have a regulation. So, there you go. Yeah. I won't repeat what I've said before about the caveats. I'll just say that the legal frameworks exist. We have the means to hold corporate entities accountable. It takes tenacity. It takes some kind of resources. A major point to look at, if we look at pragmatically, is the differences between different legal cultures, between common law lawyers and civil law lawyers. For example, punitive damages. Punitive damages comes from the US. In Israel, it was accepted into domestic law only recently. So making it worth the while for example, terrorist victims to carry on with trials, civil lawsuits, because they do receive money from Social Security. So for it to be, civil reparations are, they're evened out with what you receive in Social Security. So for it to be worthwhile, punitive damages have to be instated. In civil law jurisdictions, punitive damages are an insult. Okay, so it's not accepted. It's absolutely uncoincidentally and ideologically rejected. And the second point is percentages for lawyers. So in the US, only percentages. In Israel, maybe half-half. Again, in the UK or in France or in European settings, it's an insult. in order to represent victims. Many times they are vulnerable populations. They don't have the means to be sustainable representing victims. You need either a fund or an NGO. Entities providing money try to sometimes influence your legal actions. You want to be free and look at the victim's interests foremost. And so in order for it to be sustainable, you need to have some kind of system that is will allow you to represent them also in dignity. Yeah, I'll end there.
Thank you very much.
Thank you.
It's for Yale, and it's about the relationship between how much you can cross-apply lessons for engaging in armed groups with corporate actors. And as you know, I was involved in doing a piece of research, the piece of research you referred to, for the Special Rapporteur on Transitional Justice, and so I was very live to that issue. How much can you transfer the experiences across? So my question is, as you were speaking there, that occurred to me is on the issue of deterrence. So one of the things that I and others have looked at over the years is whether or not international criminal lawyers in particular make assumptions that part of the function of the international criminal law is to deter in the future. And I used to be a criminologist, and some of the assumptions around deterrence are very lazy for international lawyers, to be frank. So as I said yesterday, you know, when people joined the IRA, they were told, you're going to jail or you're going to die, right? There's a brilliant piece of research done by, it's a political scientist, I think, about the life expectancy of people who are involved in military coups in Africa, right? And the life expectancy of people who are involved, and basically over 60% of them end up dead, right? So if you were a rational, calculating armed group actor involved in violence, you'd think, if we look at the numbers, if we look at the stats, it's not great. You know, your life expectancy is not great. And so I think that sometimes lawyers are too simplistic about their assumptions about the utility of deterrence as a rationale for legal regulation, particularly with non-state actors. However, as you were speaking, Yael, I was thinking, is it more relevant for corporate actors who are rational thinking, calculating entities, and therefore does this idea about, you know, working and extending international criminal law to cover corporate actors, is deterrence a more useful frame there, more relevant than it is for non-state armed groups? That's my question.
So I just entered the final presentation, I'm sorry. But I want to ask Yael a question. And it's actually two questions. So the first is that in various other areas of human rights law, we see more and more frameworks, legal frameworks that apply responsibility to corporations. So in my field, you know, the supply chains, so corporations along the supply chain, you have a lot of regulation there. And also now with the new technologies, with AI, you see the proposed EU AI Act that applies responsibilities and very severe responsibilities to AI companies along the chain. And so I was wondering whether this line of thought has filtered in any way, not through tort law or the other means that you described, but really international human rights instrument against humanitarian law that applies such responsibility to corporations. Because from your description, and perhaps I missed something, it seems that it's not the case. And I was wondering why this trend or acknowledgement that corporations have to be responsible for human rights at the international level hasn't entered this specific field of human rights law. The second question is also related to AI or to new technologies, because in practice, much of the a lot of groups, be it state groups or corporate groups, use these technologies. So Do you think that, for example, the proposed EU AI Act or placing responsibilities for those using AI technologies or other sorts of technologies in a very strict way might be beneficial for thinking about corporate responsibility in your area too, because it will require them to be very rigorous in the way they use AI when it might affect human beings?
Thank you.
Are there any other questions before we go into answering? I'll add a question of my own to Sorka on Zoom. If you could please kindly elaborate a bit on possible changes, how you can imagine changing the incentive structure in order to bring private sector, the security, military and security companies and mercenaries into the table, or include them in any way, shape, or form, so to change that imbalance in incentives that you described in your paper. So we'll answer those questions and then we'll see if there's another round. So,
And if I can add a question to Camille just to even out, because I have a question. And
definitely.
I was very interested in the Chiquita case. And if you could perhaps say a few words, what was the legal framework there for accountability under the HEP? Then it would be great.
So I'll go ahead and answer your question.
Okay, so thank you for the questions. So first, Kieran, deterrence, and is there a comparative between corporate entities and non-state armed groups? Definitely more effective there. You know, non-state armed groups or any actors who are ideologically involved, like any one of us, sort of civilians of a conflict, often feel like they don't have a choice. It's maybe we sometimes live in denial that we do have a choice, but we're definitely affected, and that is crucially different with corporate entities looking for a good place to invest. Where would you invest? A place where you're entering an armed conflict, you're going to deal with non-state militias, and they're the ones legislating and all that. You would perhaps think twice. So definitely yes. I hope that answers the question. Is it worth it? No, it's not worth it. And do I have a choice? Usually corporate entities do, especially multinationals that are involved in this. Einat, so thank you for the questions. It actually touches directly to the research I'm doing now on emergency medicine, so MCIs, mass casualty incidents, disasters, etc., integrating advanced technology and looking at the legal, societal, humanitarian, ethical aspects of AI. Now, I'm not sure if what I said is there's no accountability, or there is accountability, but what the framework of that you're referring to, so it's more under the UN Guiding Principles of Business and Human Rights, translated into one tool called Human Rights Due Diligence. And that's what the EU Draft Act is doing. That's what the French vigilance law is doing, and national human rights due diligence. Now, what that means, that's where the controversy is. Also, to what extent is there judicial review over what that means? There's a controversy, and there was the first French decision on the vigilance law just a few weeks ago on Total Energies, and did they abide by their obligation to human rights due diligence under the vigilance law in terms of environmental harm? And the court there actually took a limitative interpretation on its power to review, judicial review. They said the law wasn't explicit enough, and therefore they didn't sanction the Total, and they rejected the case. So I hope that answers your question. And the second question was, I'm not sure I understood it, was the whether AI can contribute to the commission of crime, or
to the placing of responsibility on corporations that use this AI system, and therefore don't apply direct responsibility of them as corporation, but rather as those that start to use these technologies, and then you get the responsibility from other fields of regulation that will actually eventually.
Right. So I truly believe that the business and human rights is in development, but that there are existing mechanisms already When we talk about responsibility for use of AI and also the relation between responsibility between man and machine, where is that responsibility? The focus is on responsibility by design. Also the draft EU directive on AI is a risk-based approach. So the obligation is to identify your risks at the earliest stage and mitigate your risks. And the obligation also under the vigilance law is to report this process. So it's more of, right now what generally states and regions, OECD, EU are doing is regulating through, it's a bit like tax law. It's like, instead of saying don't launder money, you have to report on transfers of money, for example. So it's more, they're focusing on the reporting. Did you report your human rights due diligence? Did you do that process within your company and also outside on the impact of your activity or not, including on AI? And of course, there is responsibility for how AI is used. But it goes down to existing civil and criminal law, meaning there's going to be heterogeneity from country to country.
Thank you. Sorka, do you want to?
Yeah. Can I just make sure that I heard the question correctly? You were asking about how can we include PMSCs in the accountability frameworks? Was that the gist of the?
Yeah. How can we? Because you mentioned the disincentives. Can we increase incentives or create some sort of balance in order to get them more willingly into the table?
Yeah, I mean, I think with mercenaries, I'm going to create a bit of an artificial distinction here, but if we're thinking about mercenaries in terms of combatants, and you think about how mercenaries are being used in contemporary armed conflicts, they're being used for geopolitical reasons, and I'm not sure that there's going to be any incentive, or that you would even want them to be at the table in any kind of peace process, mediation, transitional justice process. I mean, there are, over and above the Geneva Convention, there's two conventions that criminalize the act of recruitment, training, and financing and deployment, and the act of being a mercenary. And the UN, you've got the African Union Convention and the UN Convention on Mercenarism. There are only 37 state parties to the UN Convention, but both of those instruments envisage that states will implement domestic provisions at the national level to criminalize those different activities, but they're really disparate in different countries. So you have some countries that have fully implemented a criminal law framework, which in theory could hold individuals to account, and then other countries that are not party to that convention. I'm based in Denmark, and Denmark has a provision which criminalizes the recruitment of mercenaries, but nothing else. And you see that sort of replicated in other countries. And some countries have nothing. Some countries have a sort of strict liability approach. So if you look at Switzerland, Switzerland has, under its military code of criminal justice, an absolute prohibition on any Swiss national fighting for anyone other than Switzerland. And so we've seen that being used, not recently against mercenaries, but certainly against returning foreign fighters from Syria, for example. Now, if we think about private military and security companies, I think with both types of actor, the way to go here is to try to prevent them. We want to prevent their use in the first instance, or if they're going to be used, we want to make sure that they're operating within a framework that is in fact human rights compliant. And of course, that's the challenge. I mean, we're not going to stop states outsourcing security to the private sector. That ship sailed a long time ago, and so I think the reality is that we have to try to make them, at least on the private military security side, we have to make them comply with international human rights standards. And there's a whole raft of mechanisms that are trying to do that. So you've got the Montreux document, which sort of systematizes existing international legal provisions that apply to private military and security companies, and reminds the different state actors, whether they are the host state, whether the contracting state, whether they are the sending state, it's the territorial state, whether it reminds them that they do have obligations to make sure that these actors are in fact complying with international human rights law and international humanitarian law. You've also got the International Code of Conduct for private security providers. So this is very much focused on actors that, these are actors that are not, they're not engaging in combat activities, but they are operating in situations where there might be an armed conflict or what's called a complex environment. Now that system envisages that companies demonstrate their compliance with the International Code of Conduct through third-party auditing and certification. Now that in itself, those layers are hugely problematic, and I've written elsewhere about the limitations and the weaknesses of using third-party auditing and certification in the security sector. So, for example, the code names sort of 6 specific human rights violations that these companies might be involved in relation. So it talks about the right to life, the right to be free from torture, child labour, trafficking, and then rights around detention. I think those are the 5-6 key points. And what that means is that when companies are being audited, they tend to focus only on those rights. They don't understand human rights in a broader sense. And the auditing is also very, very challenging. So they don't take an intersectional approach. They don't understand how there might be different differentiated impacts on groups in particularly vulnerable situations. So, there are real challenges around those codes, and not least there's a potential for the certification standards, the audit standards, to be co-opted by the industry. So we've been looking at updating, for example, the PSC1 audit standard, and we see a push there for, let's reduce the human rights elements. Let's push for inclusion of ESG, non-justiciable rights. And so there's a concern about corporate capture. But states also have to step up. There are only 7 states that are members of the International Code of Conduct Association. I think it's 53 states are members of the Montreux Document Forum. So states are really needing to step up. And we can see that they're not in the open-ended intergovernmental working group processes at the UN, which are, there's a specific process trying to create an instrument specifically on private military and security companies to address the gaps, because PMSEs fall through the gaps. If they can't be defined as mercenaries, it's very problematic. And we've been hearing about the UN guiding principles. There's been a push by the industry, by the PMSC industry, to say, well, we're just like any other business, and we want to comply with the UN guiding principles on business and human rights. But the reality is they are different from your other forms of business. They are given the right to use force. They use weapons. In some cases they use firearms. They have, in some cases, the right to detain people. Other business, they can be differentiated from other businesses. So I think the guiding principles are useful absolutely as an umbrella framework for the security industry, but it's really important that there is additional regulation of them that both prevents violations by them, but also provides remedies and accountability for victims. I can go into those in lots more detail, but I don't want to bore you and take up too much more time.
Thank you very much. And Camilo, last remark.
Okay, thank you for the question. Okay, it is a good question because during my presentation I talk about the possibility to enter this kind of collective entity inside the HEP. But the big question is, what is the legal framework that HEP can be applied? Because we have some resources in law, as well as the domestic criminal code, but we have ISL, or we have signed for Geneva Conventions and additional protocols and Rome Statute. But as you said, there is not a possibility to judge and prosecute the collective entity of fiction that there is. But during some discussions inside of the HEP, one of the possibility is to apply the Nuremberg formula, the double imputation, against the collective entity or company, as happened with the Nazi party, and prosecute the current high decision maker. But it has different issues with the legality principle, because some facts and behaviors what happen with other people, it could be difficult. But yeah, I don't have a specific answer, but this is the current analysis for this topic. Yeah.
So, thank you, everyone. We'll have to conclude for now, but you can ask questions in the break. Thank you, everyone, for the presentations. Thank you to the organizers and for you. Now we have a lunch break until 45 minutes, and then we'll continue for the next sessions and the rest of the day. So thank you so much. Thank you again for our participants, our presenters. Thank you very much.